Welcome to the debate. Imagine stepping into a tribunal. Your entire livelihood is on the line.
Right.
You have brought reams of evidence, documented facts, and a clear legal argument. But before your evidence is even fully weighed, the judge looks at you, sighs, and says, "I think I know what the parties want."
Which is just an unbelievable thing to hear in a courtroom.
It really is. I mean, the gavel essentially comes down. Your case is over before it truly started, decided not by facts, but by a judge's momentary assumption. So today we are examining the fundamental mechanics of judicial decision-making and accountability.
Yeah.
Specifically, we're focusing on the concepts of duty process separation and reconstructable decisions.
And we are grounding this entire discourse in a very specific, highly revealing piece of source material. The text detailing the NWAF standard, which uses the preliminary hearing of June 30th, 2026 as a definitive case study of a complete systemic breakdown.
Exactly. The core question we really have to grapple with today is this. When a tribunal decision breaks down entirely, failing to document reasoning, failing to evaluate evidence, and, substituting assumption for law, does this indicate a structural governance failure requiring a new architecture like the NWAF standard? Or is this a localized failure of legal competence, one that should be addressed through our existing appellate and judicial mechanisms? Right. And I argue that the June 30th hearing proves definitively that tribunals suffer from a massive systemic governance gap, one that makes the structural oversight of the NWAF standard absolutely necessary to protect the public.
And I contend that these events, while completely catastrophic for the parties involved, are fundamental errors of law. They require traditional appellate correction rather than the imposition of a rigid corporate-style governance architecture onto independent judges.
Let's jump right into the heart of this. As I read the NWAF source material, a really chilling reality emerges. Fairness in our tribunals is currently an illusion.
An illusion? That's a strong word.
It is, but it's accurate. It's an illusion because it relies entirely on individual judicial discretion rather than a governed process. If you are listening to this and thinking, wait, aren't judges supposed to know and apply the law? You aren't alone.
Right. That's the baseline expectation.
Yes. A tribunal has a fixed, non-discretionary legal duty. That duty is to consider the evidence presented, apply the correct statutory tests, and follow natural justice. But because there is no external structural governance forcing a judge to map their process to that duty, the two diverge. On June 30th, the process utilized was entirely assumption-based and totally undocumented. When there is no system forcing process to reflect duty, fairness is no longer a guarantee. It is, it's just optional.
I come at it from a different way. I do not disagree for a single moment that the June 30th hearing was a catastrophe of justice.
We are looking at a judge who completely failed to provide findings of fact.
Right. In the legal world, that is a direct breach of Rule 62, the absolute baseline requirement that a judge must explain the reasons for their decision. The judge also chose to completely ignore material admissions from the respondents.
Unbelievable.
Truly. These are appalling textbook breaches of judicial duty. But I fundamentally dispute the NWAF premise that this is a quote-unquote process failure solvable by imposing governance thresholds.
Wait, why isn't it a process failure? The process the judge used was literally broken.
Because calling it a process failure almost gives it too much credit.
Oh, interesting.
It treats a profound violation of jurisprudential duty as if it were just, a missing administrative checklist. These are direct violations of existing binding legal duties. When we start talking about introducing corporate-style concepts like accountable attribution into the courtroom, we risk profoundly undermining judicial independence.
Do we, though?
Yes, absolutely. We risk forcing judges into defensive box-ticking exercises rather than allowing them to engage in the nuanced, complex legal reasoning that actual justice requires. The architecture you are advocating for attempts to administratively manage legal thought. That is a dangerous line to cross.
But let's look at what happens when we don't manage it, right? Let's move from the abstract fear of box ticking to the reality of what the text calls reconstructability.
Okay.
This is a vital concept for the audience to understand. A reconstructable decision is like showing your work in a high school math class. If you just write down the answer 42 at the bottom of the page, the teacher doesn't know if you used the correct formula, or if you just guessed, or if you copied it from the person next to you.
Right. The chain of legal logic must remain unbroken and visible.
Exactly. But on June 30th, the tribunals accepted 42 without seeing the math. None of that reconstructability existed. Instead, we got that chilling remark, "I think I know what the parties want."
Yeah, it's bad.
It is pure predetermination. It replaces the rigorous evaluation of evidence with a personal assumption. The judge preferred bare, unsupported denials from one side over extensive, documented evidence from the other. How can we possibly rely on the current system when a judge can legally close a hearing without a lawful basis, remove observers from the room, and render a decision that has zero traceable path from fact to outcome? Reconstructability didn't just bend on June 30th. It was entirely absent.
I'm sorry, but I just don't buy that. Let me tell you why I reject the conclusion you were drawing from that very real failure.
All right.
Yes, the judge saying, "I think I know what the parties want," is predetermination. Yes, failing to show the math is a massive error, but predetermination is already illegal under the deeply entrenched principles of natural justice. Let's look at the specific mechanisms the judge butchered, the strikeout and deposit tests.
Oh, let's translate those for the listeners really quickly.
Absolutely. So a strikeout is when a judge throws your case out completely because it has no reasonable prospect of success. It is a massive final step.
Right.
A deposit order is when a judge says your case is incredibly weak, so you have to pay a financial deposit, often thousands of pounds, just to be allowed to continue. Both of these tests require a high legal bar. They require the judge to actively evaluate the evidence.
Which didn't happen.
Exactly. On June 30th, the judge misapplied these tests without any evidential basis whatsoever. They just threw them at the claimant. That is a fundamental irrationality. But here is my point. The legal system already has a mechanism designed specifically to catch and correct fundamental irrationalities.
The appeal system.
Yes, it is called the appeal system. You don't need a new convoluted corporate governance standard to tell a judge they cannot predetermine an outcome. The law already dictates that. A failure to follow the law doesn't mean the structure of the law is missing. It means the individual judge failed their duty, and we have appellate courts to fix it.
See, I'm not convinced by that line of reasoning because you are treating the appeal system as if it is a preventative measure, and it is emphatically not.
Well,
Think of a hospital. A surgeon has a fixed, ethical, and legal duty to save lives and do no harm. That is their jurisprudential duty, to borrow your framing.
okay, sure.
But if a hospital has no governed process, if there is no mandatory pre-op checklist, no scrub-in protocol, no, digital lock preventing them from operating on the wrong limb, errors are going to happen regardless of how deep the surgeon's medical knowledge is.
And I see where you're going with this.
Right? The tribunal system currently operates like a hospital with no checklists, relying entirely on the surgeon's memory and mood on any given Tuesday. The appeals process you are defending, that is just an autopsy.
An autopsy.
Yes, it only catches the error after the patient has already been harmed. It provides absolutely zero proactive protection.
It is an autopsy that can reverse the legal death, so to speak, by overturning the decision. But I will certainly take your point regarding the reactive nature of appeals. They do happen after the fact.
And building on that idea of autopsies versus checklists, we have to address the massive systemic oversight gap the text clearly identifies. There is a staggering asymmetry in how we treat regular employees versus how we treat the judiciary.
Well, if you run a business, you are literally compelled by agencies like the Fair Work Agency to keep your staff updated on compliance, on procedural changes, on new laws. If you don't, you get fined or shut down. But who ensures tribunal judges stay updated?
Well, the expectation is that highly trained legal professionals are self-updating. They read the case law.
But that is exactly the problem. It is an expectation, not a governed requirement. Yes, the Judicial College provides training, but attendance isn't universally audited in a way that stops a judge from hearing a case.
Right.
Tribunal presidents issue practice directions, but they don't sit there monitoring individual judges or auditing the quality of their reasoning before a decision is finalized. This lack of proactive governance led directly to the horrifying Equality Act breaches we saw on June 30th.
The treatment of the disabled party.
Yes, and we need to be really clear about what happened there so people understand the stakes. The Equality Act exists to protect disabled individuals, requiring reasonable adjustments so they can participate equally.
Exactly.
But in this hearing, the disabled parties' specific disability-related limitations were somehow weaponized against them. The judge treated their need for accommodation as procedural noncompliance and actually penalized them with those financial deposit orders we talked about earlier.
It's awful.
Meanwhile, the respondents in the case made clear admissions about manipulating scores, which is a massive piece of evidence, and the judge ignored it entirely. That perverse flipping of the law doesn't happen in a governed system. That only happens when oversight is completely absent and a judge is operating in an unaudited silo.
That's a compelling argument. But have you considered the fundamental difference between the nature of employment and the nature of the judiciary?
I mean, they're different, sure, but
The judiciary is not an employer-employee relationship. A judge is not a corporate middle manager executing a rigid workflow on a factory floor. They are independent arbiters of complex law.
right, but independence shouldn't mean lack of accountability.
I fully acknowledge the severity of the unequal treatment on June 30th. Penalizing a disabled party for their limitations while entirely excusing the respondent's documented contradictions is an egregious, inexcusable procedural unfairness. But forcing judges into a non-discretionary standard of continuous administrative oversight fundamentally misunderstands what actually happens in a courtroom.
How so? Because from the outside, a courtroom just looks like a place where rules should be strictly followed.
Because human conflict is inherently messy. Hearings are dynamic. Witnesses break down. Unexpected evidence comes to light in the middle of cross-examination. Not every single procedural anomaly can be mapped to a predetermined digital governance architecture.
But we aren't talking about a witness crying. We are talking about severe procedural anomalies, like allowing an explicitly dismissed party to remain in the hearing room, which happened on June 30th.
Exactly. And the text rightly notes that allowing a dismissed party to remain is highly irregular and deeply prejudicial. It is a procedural error. But if we mandate a system where a judge must satisfy a literal governed threshold in an administrative software system for every single person remaining in a room, we paralyze the court's ability to manage its own proceedings.
It wouldn't paralyze them. It would just...
Judicial discretion isn't a loophole that needs to be closed. It is a necessary, vital tool for managing the infinite, unpredictable variations of human conflict that end up in a tribunal. Imposing the NWAF standard risks reducing complex human legal management to a rigid, binary, algorithmic process.
I see why you think that, but let me give you a different perspective on what the NWAF standard actually requires. Because it is not about paralyzing a judge with mindless bureaucratic checklists. It is about accountable attribution.
Accountable attribution.
Yes. Let's explain how that functions. Accountable attribution means that every judicial outcome must be directly, traceably linked to a specific piece of evidence and a specific statutory rule. It separates the duty, the requirement to apply the law, from the process, the way the judge structures the hearing.
Okay.
It essentially says, Judge, you have discretion on how you run the room, but before you can issue a strikeout, you must explicitly link this decision to the evidentiary standard. We know we desperately need this architecture because we saw what happened with the misapplication of the Hendricks Continuing Act law on June 30th.
Right. The exclusion of the pre-2024 conduct.
Correct. For the listeners, the Hendricks Continuing Act precedent is a vital piece of discrimination law. It essentially says that if someone is subjected to a campaign of discrimination over several years, the court should treat it as one long continuing act rather than chopping it up and saying the older events are out of time.
It protects victims of long-term harassment.
Exactly. But on June 30th, the judge just arbitrarily excluded all conduct before 2024. No legal basis.
Nothing.
No explanation. They just completely ignored settled continuing acts law. Why? Because judges cannot be left to self-update. When the law evolves but the judge's internal, undocumented process does not evolve with it, ordinary people pay the ultimate price.
They are the ones who suffer the unpredictable outcomes. They are the ones who have to bankrupt themselves to fund your so-called autopsy in the appellate courts. Proactive governance through a framework like NWAF, forcing the judge to literally cite the legal pathway before the decision is accepted, is the only way to protect the public from an unaudited judiciary that allows personal impressions to replace established law.
The failure to apply the Hendricks Continuing Acts law isn't a failure of governance architecture. It is a failure of basic legal training and competence.
But isn't that a governance issue? No, because the NWAF framework you are praising is inherently an administrative tool. You are attempting to use an administrative framework to solve a jurisprudential problem. Yes, the judge failed to provide an evidence-based pathway. Yes, they relied on undocumented, incredibly flawed reasoning, but replacing our traditional legal system with continuous administrative audits of judicial reasoning crosses a dangerous democratic line.
I don't see how ensuring a judge follows the law is crossing a democratic line.
Because you have to ask who audits the auditor, who decides if the judge's reasoning meets this new governed threshold.
Well, the framework itself,
If it is an external administrative body or a rigid set of NWAF criteria, you have effectively destroyed the separation of powers. You are no longer allowing judges to interpret the law. You are controlling judicial thought under the guise of accountable attribution. You are telling judges you can only think in the ways this system allows you to think.
That's an interesting point, though. I would frame it quite differently. I'm not suggesting we control judicial thought. I'm pointing out that if the thought isn't reconstructable, how can we even call it judicial? If a judge provides no findings of fact, no documented reasoning, and no legal pathway, as happened under the appalling Rule 62 breach, there is literally nothing for the appeals court to even review. The autopsy can't happen if the body is missing.
Which is exactly why the appellate court would remit the decision, back down, or overturn it entirely unsafe. The mechanism works. When a judge fails to provide reasons, the appellate court recognizes it as an error of law and intervenes.
But again, only after the damage is done.
I will grant you wholeheartedly that the current reactive system requires immense resources from the parties involved. It takes time, it takes money, and it certainly leaves systemic issues invisible to the broader public, because only those with deep pockets can afford to appeal a bad decision. But the cure of continuous external administrative governance risks being far worse than the disease of localized incompetence.
Let's pull back and summarize where we stand on this. Because we are looking at the exact same systemic failure, the absolute collapse of justice on June 30th, and seeing two very different paths forward.
We certainly are.
my position remains that the June 30th preliminary hearing is undeniable empirical proof that an unaudited judiciary is an unpredictable and dangerous one. By failing to structurally separate the duty of a judge from their internal process, tribunals allow convenience, impression, and personal assumption to completely override the law. We simply cannot rely on a system where fairness is contingent on a judge's memory, their mood, or their willingness to self-update on precedents like Hendricks.
Right.
The NWAF standard provides a necessary structural shift. It moves us away from a reactive system of harm correction, where ordinary people pay the price of admission to an appeals court, to a proactive system of reconstructable justice, where reasoning must be documented and validated before the harm ever occurs.
And my summary is this. The events of June 30th represent an appalling, inexcusable breakdown of evidential principles, natural justice, and statutory duty. No judge should ever decide an outcome based on an arrogant assumption of what parties want, nor should they ever ignore material admissions of wrongdoing like score manipulation.
Exactly.
But treating judicial reasoning as if it were just a corporate workflow to be managed through external governance thresholds and accountable attribution fundamentally misunderstands the judiciary. It risks undermining the independent, discretionary nature of legal duty. The remedy for bad judging is not an administrative architecture. It is the rigorous, unyielding enforcement of legal accountability through our appellate courts, strengthening the judicial prudential standards we have relied on for centuries.
I think where we strongly converge today is on the profound inadequacy of relying exclusively on appeals as our only form of oversight.
Because that system is so incredibly resource-heavy, it means errors are only ever caught after the financial and emotional harm has occurred. And the systemic underlying issues that cause those errors remain dangerously invisible to the public.
Absolutely. The disparity between an employer's strict, governed obligation to keep their staff updated and the lack of a mandatory updating mechanism for tribunal judges is a structural reality that we cannot ignore. Examining these failures through both a structural governance lens and a strict legal lens provides a much sharper, more honest picture of the problem.
It really does. I highly encourage everyone listening to explore the NWAF source material further. Delve into the specific, intricate details of the June 30th hearing, look at the mechanics of reconstructable decision-making, and evaluate for yourself how we can best ensure accountability in our courtrooms. Because at the end of the day, we have to decide what kind of structure we want to trust with our livelihoods.
Yeah.
We have to decide if we want a justice system that implements the safeguards to prevent the harm in the first place, or one that merely performs a very precise autopsy after the fact.